Welcome back to the deep dive, where we go straight into the source material to really understand complex topics.
That's right.
We're pushing forward in our series on the Manual of Patent Examining Procedure, the MPE, your guide to, well, getting a patent through the USPTO.
And today we're in MPP Chapter 1800. That's the chapter all about the Patent Cooperation Treaty, the PCT, the international system.
Right, the one application, many countries route.
Exactly. And specifically, we're zeroing in on Section 1853. It's titled Amendment under PCT Article 19.
Okay, Article 19 amendments. So this deep dive is about understanding like a really specific chance you get in the international patent process.
Precisely. Think of it as this single strategic window. It's your one opportunity, under Article 19 anyway, to adjust your claims after you see the results from the international search.
Okay, after the search.
But before the whole world sees your application when it gets published internationally. And the rules are, well, very specific.
One-shot specific rules.
Yeah.
Got it. So what's the core idea here?
The core idea in MPP Section 1853 is pretty straightforward. As an applicant, you have the right to make one set of amendments during this international phase.
One set. And you mentioned claims.
Yes, and that's crucial. These amendments, they can only be made to your claims, not the description, not the drawings, just the claims.
And the trigger, you said, is getting that international search report, the ISR.
Exactly right. The International Searching Authority, the ISA, does its search for prior art, tells you what it found, and gives you an opinion on patentability. This Article 19 right is your direct chance to respond to that specific information.
So you get the ISR, you digest it, and then boom, here's your chance to tweak the claims based on what they found.
That's the idea. And you don't send these amendments back to the ISA or even the USPTO if they acted as ISA.
Oh, where do they go?
They go directly to the International Bureau, the IAB. They're sort of the central administrators for the whole PCT system based in Geneva.
Okay, send them to the IB. Why would you take this step? What's the strategy beyond just fixing potential problems the ISR pointed out?
Well, fixing problems is definitely part of it, putting your claims in better shape. But the MPP points to another strategic reason. Improving your position for provisional protection in the countries you've designated.
Provisional protection. That's like rights you might get before the patent actually grants.
Yeah, in many countries, once your international application publishes, you might get some level of provisional rights. It can, put potential infringers on notice.
Okay.
So amending your claims under Article 19 means the version that gets published might be stronger, clearer, maybe narrower to avoid the art found in the ISR. This potentially makes that provisional protection more effective down the line.
So it's about putting your best foot forward, claim-wise, when the application becomes public. That makes a lot of sense. Okay, deadlines. Always critical in patent law. How tight is the timing for Article 19?
Oh, it's absolutely critical. The MPP is very clear. Miss the deadline, and you generally lose this specific right.
So what is it?
It's the later of two dates. Pay attention here, the later one. Either 2 months from the date the international search report was mailed to you.
2 months from mailing. Got it.
Or 16 months from your application's priority date.
Priority date.
Yeah,
That's
yeah.
your earliest filing date for this invention, right? The one that sets your place in line.
That's the one. Your earliest effective filing date. So calculate both dates, 2 months from ISR mailing, 16 months from priority, and whichever date is later, that's your deadline.
A later of the two. Okay. Is there any wiggle room? Like, if you're a day late...
The text mentions a possibility, but you really shouldn't rely on it. The IB might accept late amendments if they get them before they finish the technical preparations for publishing your application.
Before they hit the publish button, basically.
Essentially, but that's a huge gamble. You don't know exactly when that happens. The safe play, the only real play, is to hit that calculated deadline.
Message received. Hit the deadline. Okay, so claims only, after ISR, before publication, submitted to the IB, strict deadline. Let's talk about what you can change in those claims and, maybe more importantly, what you can't.
Right. So you can obviously amend the text of the claims, reword them, combine features from different original claims, cancel claims entirely, add new claims.
If they have basis, I assume. We'll get to that.
Yes, absolutely, if they have basis in the original disclosure. But the big cannot for Article 19 is you cannot touch the description or the drawings. Those are off limits for this procedure.
So even if the ISR makes you realize, oh, this part of the description is unclear, or this drawing could be better, You can't fix it here.
Not with an Article 19 amendment, no. Now, the MPP does mention you might get another chance later under PCT Article 34
Okay.
to amend the claims and the description and drawings. But that's only if you file a formal demand for international preliminary examination. That's a whole separate step. Costs extra money. Not everyone does it. Article 19 is your automatic shot after the ISR, but it's claims only.
Got it. Article 19, claims only. What about adding totally new ideas? Stuff you forgot to put in the first time?
Ugh, the cardinal sin. No. Absolutely not. Article 19 amendments cannot add new subject matter. Anything you put in an amended claim must have been disclosed in your international application as it was originally filed. Full stop.
Even if adding it would make the invention clearly patentable over the prior art.
Doesn't matter. The rule against new matter is fundamental. Now, typically the real enforcement of whether you complied with this happens later during the national phase when examiners in each country look closely.
Right.
But the rule itself applies at the time you make the Article 19 amendment. You can't use this as a loophole to add things you missed initially.
Okay. No new matter. Are there times when you don't even get this Article 19 chance at all?
Yes. One main situation. If the ISA, the searching authority, decides they are not going to issue an international search report.
Why would they do that?
Well, maybe the subject matter is something they don't search, like, perpetual motion machines or certain business methods depending on the office. Or maybe the application is just so unclear under PCT Article 17.2 that they can't figure out what to search.
Okay.
If that happens and you get a declaration saying no ISR will be established, then you also lose the right to amend under Article 19. The right is tied to receiving an ISR.
That makes sense. The amendment is a reaction to the search. No search, nothing to react to under this specific article. Okay, procedures.
Yeah.
You said the rules are specific. The MPEP stresses getting the formalities right.
Oh, absolutely. Procedural precision is paramount. Mess this up and your amendments might just be ignored or cause major headaches later in the national phase.
So how do you do it right? What's the first step?
First key thing. You don't just send like a list of changes or the claims you change. You must file a complete, clean replacement set of all the claims.
Replace the entire claim section, from claim 1 to the end.
The whole thing, as you want it to read after the amendment. Think of it as substituting the whole claim section.
Okay.
And critically, this replacement set must come with a letter, a mandatory letter. And this letter isn't just a cover sheet. It has very specific required content.
Mandatory letter. What needs to be in it?
Okay, two main things. First, it has to identify the differences. Which claims are unchanged? Which original claims did you amend? Which did you cancel? Which new claims did you add?
Like a status report for every claim number.
Exactly. But second, and this is where people often slip up, it must provide the exact basis for every single amendment and every single new claim. You have to point to where in your originally filed application that change comes from.
Show your work, basically. Prove it wasn't new matter.
That's precisely it. You need to say, the language added to Claim 1 comes from paragraph 0042 of the original description, or new Claim 15 is based on original Claim 3 combined with Figure 2. You need those specific references.
Wow, that detailed. Why demand that level of precision right at this stage?
It goes back to that no new matter rule and the purpose of publication. By forcing you to explicitly state the basis now, the system creates a record showing that the claims being published internationally are, theoretically, supported by the original disclosure.
It prevents publishing potentially unsupported claims.
Right. It helps maintain the integrity of the publication and signals to national offices later where to look for support. It reinforces that you can't expand beyond your initial filing.
Okay, that makes the meticulousness make sense. Let's use the examples from the NDKP. Say I amend Claim 1 to add a periodic backwashing means serially coupled to a first and second chamber. What does my letter need?
Your letter must state, for example, that this specific language, this periodic backwashing means phrase, is derived from, say, original claims 2 and 4 as filed. You point right to the source.
And if I add a totally new Claim 18 talking about a quick-fire piston?
And your letter has to point to where that quick-fire piston was described in the original application. Maybe it's in paragraphs 0055, 0058 of the description as filed, or maybe it's clearly shown and labeled in, say, drawing no 3. You need that precise citation back to the original document.
Okay, replacement claims, mandatory letter, detailed changes, exact basis cited. Sounds like a checklist you really need to follow. Any other formal requirements? Language.
Yes. The replacement claims themselves have to be in the language of international publication for your application. And, they need to be properly formatted, clean copies, following all the PCT rules for presentation. Mistakes here can cause delays or problems.
So that's the mandatory stuff. Is there anything optional you can file along with this?
Yes, there is. You're allowed to submit an optional brief statement.
Optional statement, what's that for?
It's quite limited, maximum 500 words, and it has to be in English regardless of the application language. The idea is to let you briefly explain the amendments you made.
Explain them.
Yeah, and maybe explain their potential impact on or relationship to the description and drawings, even though you couldn't actually amend the description or drawings themselves under Article 19.
Interesting. So you can't change the description, but you can sort of add commentary linking your new claims back to it.
Kind of like that, yes, providing context. But again, strict rules apply to what this statement cannot contain.
Okay, what's forbidden?
Two big ones. It must not contain any criticisms of the International Search Report. No arguing with the ISA's findings here.
Don't argue with the ref. Got it.
And it must not include citations like citations to prior art references or court cases or anything like that.
Just explain your amendments. Don't argue or cite external stuff.
Exactly. And procedurally, you need to give it a clear heading, like statement under Article 19.1, so the ID knows what it is.
Okay. This deep dive into 1853 shows it's a very specific procedure-heavy opportunity. Let's recap the absolute key takeaways.
Okay. Article 19 amendment. It's your single chance during the international phase to adjust things based on the ISR.
It happens after you get the ISR and before international publication. And you have a strict deadline. The later of 2 months from the ISR mailing or 16 months from your priority date.
You can only amend the claims. Description and drawings are off limits in this procedure. You might add an optional explanatory statement, though.
Critically, no new matter. You cannot add anything not disclosed in your original application.
And the procedure is key. File a complete replacement set of claims. Accompany it with a mandatory letter detailing all changes, cancellations, additions. And crucially, that letter must give the precise basis in the originally filed application for every single change.
Getting that basis right is non-negotiable proof against adding new matter. You know, this whole process, this single, very controlled chance, really highlights how interconnected and, frankly, demanding the international patent system is.
It really does. It's this focal point where you take early feedback, the ISR, and you try to strategically refine your invention's legal definition, the claims, within tight constraints right before it goes public globally.
What you do here can really set the stage for how things play out later in all those different countries.
Definitely. Getting this step right, or choosing strategically not to use it sometimes, is a key move in that global patenting dance.
Speaking of getting things right, we definitely want to give a big thank you to Mike Shepard. He's the creative director who organized this entire MPP audio series.
Yes, thanks, Mike. And just the usual but important disclaimer here.
Right. Please remember, everyone, this summary was put together using AI tools like ChatGPT and NotebookLM. It might have errors or leave things out.
It's really for general educational and informational purposes. It is definitely not legal advice, and it's no substitute for reading the official MPEP or getting formal instruction.
Absolutely. For authoritative guidance, you need to consult the official MPP itself, talk to a qualified instructor, or, of course, speak with a registered patent practitioner.
You know, thinking about Article 19 and MPT 1853, what really stands out is how it forces you, the applicant, to constantly look back at your original filing.
How so?
Well, that whole requirement to provide the exact basis for every amendment. It hammers home that the strength and completeness of your initial disclosure dictates your flexibility later on, even internationally.
Yeah, that's a great point. It's not just about what you want the claims to be now. It's about what your original application allows them to be. Everything hinges on that foundation you laid on day one.
Exactly. Your ability to effectively use tools like Article 19 amendments really depends on how well you drafted that original application. It underscores the importance of getting that initial disclosure as complete and detailed as possible.
A crucial reminder for anyone involved in drafting applications. We hope this deep dive into MPP Section 1853 was useful. Join us next time as we continue unpacking the MPP.